One of the simple devices we use with students sometimes in the early stages is, okay, now begin writing pretending that you are the plaintiff or the prosecutor. Finish. Now, the same facts, write pretending that you are the defense counsel. Okay, now that you've taken each side, now weigh those alternatives against each other and tell me which you think is the most powerful. That final piece is really where the in-depth analysis occurs. Those first two phases are persuasive analysis. You're trying to convince someone of a position. At the end of it, however, as you start looking at both sides, and eventually you learn to not adopt one side or the other. You learn how to do that more organically. But eventually, the weighing process of the alternatives against each other is where you discover that there is a stronger position. It may not be 100% strong, but it is stronger, and you explain to me why that is.
Interesting. So I know it's probably impossible to put numbers on this, but I'm just thinking about it a little bit. On the LSAT writing sample, it's pretty much 50-50.
Yeah.
And it's meant to be that way on purpose so that, for whatever reasons, just to keep it reasonable. But in these cases that you come across, is it like, or that law students are coming across, is it 60-40? Is it 65-35? What does that look like?
Yeah, great question. The answer is, I'll give you the classic law school answer. It depends. And it depends on sometimes the subject matter. I tend to find that contracts professors, for example, create problems that have more specific answers to them, that do have a stronger final outcome to them. In contrast, torts professors and criminal law professors create problems that are, 60-40, 55-45. Now, when I say that they create a problem that's 60-40, it doesn't mean that all aspects of the problem are 60-40. One of the things you learn is, I talked about a battery a few moments ago, that the intent aspect of it may be really obvious, and that it was harmful or offensive may be really obvious. But whether it amounted to contact or not, that's where the meat of the conversation is. So something else that you learn is how to work through the simpler aspects of the problem relatively quickly so that you can spend time on the meatier aspects of the problem and work through those. And those meatier aspects, you might go through the easier aspects of an issue in 2 or 3 sentences, and it may take you 2, 3, 4, 5 pages to go through the one meaty aspect of the issue.
Nice. So it's really drilling down to the core of the issue, the crux of what will make or break the case for one side or the other, and sweeping everything else aside, getting that out of the way.
Exactly. And the difficulty that you can have is understanding that even on the simpler pieces, you have to go through the process, because things often seem simple at first blush. So you have to work through, and I always tell my students, when you were in the paradigm, one of the paradigms we use in law school for organization of an answer is IRAC. State the issue, state the rule, analyze it, and come to a conclusion. And I tell them, when you reach the analysis phase, it's actually 2 pieces. Analyze one side, analyze the other. And as early as orientation, I tell them is, you should presume that there is an opposing argument. It doesn't mean that there's always going to be one, but presume there is one until you look at it carefully and say, you know what? There are no facts that counter this. There is no reasoning that counters this. This issue is as simple as I thought it was at first blush. Okay, now let's move on to the more complicated aspects of the problem.
Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I wish you all the best and take care.